So our final segment is brought to you by GenCo Legal. GenCo Legal is rethinking how lawyers do business with legal Moneyball, the preventative law solution for your corporate legal needs and no billable hours. Joining us on Skype is my friend Sarah Casey. She's COO and partner of GenCo Legal. Welcome, Sarah.
Good morning, Carrie. Good morning, Kelly.
Oh, thanks, Sarah. Good morning to you, Sarah. After the Senate voted to confirm Kavanaugh to the Supreme Court, you understand the Judicial Watch filed a bar complaint against Ford's lawyers. Can you break this down for us?
No, absolutely. Judicial Watch is a self-described watchdog organization where they investigate claims of political corruption. They push for transparency and accountability among government officials, and they've elected to file a bar complaint, or in layman's terms, an ethics complaint, against the attorneys that represented Dr. Ford. That's Ms. Katz, Ms. Banks, and Mr. Bromwich, for not communicating enough information to their client for them to make an informed decision. And it centers primarily around her flying to DC or them coming to her to interview her, or whether she would testify publicly or privately. And what they found through FOIA, which is a Freedom of Information Act, FOIA requests and public records type investigation, that they do not believe that Dr. Ford was informed enough to make a decision on those two crucial. That's what we heard all about in the days leading up to her testimony, was whether she would do it publicly or privately and whether she would fly to DC. Obviously, we know what she did decide to do, but in hearing her testimony, it's unclear that she was informed enough to make that decision.
So just from the legal standpoint of it, what's the possible risk then to these lawyers?
Sure. So they can do anything from nothing to disbarment. And this is not something that's going to end up in them being disbarred. These are reputable lawyers who, quite frankly, had a political agenda in this process. But I think at most we'll see a public reprimand, meaning a bit of a slap on the wrist, but saying publicly that they should have handled this differently. And I think that's really appropriate in this case. I come from the perspective of a former prosecutor. I was a staunch victims' rights advocate. This is one where it came out in testimony that when asked by Ms. Mitchell, who was the prosecutor that was asking the questions of Dr. Ford, when asked whether her attorneys told her that they had offered to come to California to interview her, and that they offered to interview her privately or over the phone as opposed to in the public forum and in front of the committee, broadcast nationally and internationally, Dr. Ford said, it was not clear to me that that was the case. And she goes further to say that I was hoping they would come to me, but then I realized that was unrealistic.
Yeah, it was kind of surreal to see that in the hearing when it was clear she didn't know that it was an option.
Yeah, I want to ask a question based, Stacey, thank you, by the way. Stacey Morris has asked this question. Will lawyers hesitate to take such high-profile cases now?
I don't think so. Quite frankly, there's always a lawyer that would love to be on TV. There's plenty of lawyers with political agendas. So I don't think this will have a deterrent effect. The effect that it should have, though, is for all of us to take pause and take a step back, whether you're a Kavanaugh supporter, a Dr. Ford supporter, or you're like most of us where we're just disappointed that we'll never know the truth of what happened. How are we in a profession where the victim doesn't come first and the client doesn't come first? And the fact that she wasn't told, or was at least not told in clear terms, that she had those options. As a former prosecutor, I would never put a victim in a position of being, quite frankly, raked over the coals, having to go through a process like that, if she wasn't wanting to do that, and if she wasn't really actively participating in that decision.
Well, and Sarah, do you think also, because another issue, you mentioned the sex crimes prosecutor who was doing the questions for the Republicans, she mentioned what she had called the forensic interview, or the very in-depth, immediate interview that should happen when an alleged victim comes forward who is alleging sexual assault. And she said that didn't happen here in the case of the Democrats. They sat on this for 6 to 8 weeks. Is there any legal ramifications there possibly too, that this victim, if she was a victim and it wasn't processed correctly, is there any need to go after that, failure to treat the possible victim correctly?
That's absolutely what should have happened. And the fact that it didn't here is one of the saddest things that's happened through this whole process. The fact that they know that there's a victim out there, know that if we take everything she says as true, that there's a sexual predator out there around women and about to be appointed to the Supreme Court, that you wouldn't, even if she wanted to remain anonymous, that you wouldn't take the steps to immediately investigate that, shows that people were blinded by politics in this process, and more so that they were using her story as a political pawn. And that we see that 6 to 8 weeks before we hear anything about it, that there's the delay tactic around she doesn't want to fly. Turns out they would have gone to her. There's a September 21st email from Senator Grassley offering to send female investigators, being sensitive to the fact that she may not want to be interviewed by males, to come interview her in California. It sounds like that was never communicated to her. And that's where, as putting the former prosecutor hat on, putting the lawyer ethical hat on, we're supposed to be the profession of Abe Lincoln, advocates for our clients and zealous advocates for our clients. And here, this was all political motivation. I don't think that this is something that's going to rise to the level of obstruction of justice. Technically, it may meet the elements of that. They're not going to go after sitting Congress people for that. But it's something that we should be talking about. It's something that we should track this grievance process closely, because this is not how lawyers should be acting. And I'm a lawyer.
If nothing else, Sarah, you would think that going forward there would be a stern warning out there to all practicing attorneys to do your client no harm.
That's absolutely right. It sounds a bit like the Hippocratic Oath, doesn't it?
Yes.
Your client first, do your clients no harm. I think a public reprimand would be useful for that purpose. And I think that's appropriate in this case, because there should be a warning to other lawyers that understand these cases are sensitive. There's a lot of decisions that need to be made in real time, but your client needs to be intimately involved in those. The standard is that they are intelligently participating in the goals of the representation. And it sounds like that was news to her when she was testifying in front of the world, that was an option for her.
Well, and Sarah, to the flip side of the argument, what if for people who might say, well, this is clearly a partisan thing that the Republicans are doing to go after her lawyers, that, there might have been some miscommunication, but wouldn't the Republicans have to prove overt malice, and are they just playing politics here?
I think the emails speak for themselves. The motivations we can certainly make an educated guess at from both sides of the fence.
Right, but can you prove actual malice? Wouldn't that you'd have to prove actual malice by the part of the lawyers?
For obstruction of justice, yes, you would have to prove intent. Again, I don't think we need to go down that rabbit hole. I don't think this rises to the level of criminal activity, but it is something that is appropriate for the ethics board to hear and to make a ruling on.
So real quick, one last question for you, Sarah, about the Avenatti case, because now it appears that there's some move to penalize Michael Avenatti or investigate his work with the other case of the allegations that were printed by the New Yorker for the second case. What's your legal read on that?
They should investigate. And if it's found out that Avenatti was taking some liberties with his story or not being truthful or coaching his client in any way, because we know he loves to be on TV, we see him every other day, then he's another one that should be held accountable to the bar. We just don't know enough today to say that, and we should leave no stone unturned. This is as serious as any allegations that's made in our justice system. system, and we need to take the steps to seek the truth.
Well,
What we
the
did
downside
need
of all that is it's just going to give him more attention, which he'll then springboard into his Iowa caucus race.
that is true. And I do at least still have faith in humanity that he will absolutely get crushed with any political aspirations. Whatever side of the fence you're on, you have to recognize a bottom-feeding lawyer for what they are. And he's the worst of the worst.
Oh, you remind me of Shakespeare. Get rid of all the lawyers, except you.
Except you, Sarah.
Thank you, Kelly, for that. But there's a reason lawyers have the reputation they do. Hopefully this turns out to not be a case that happens again.
All right.
Thanks, Sarah.
Thanks, guys.